everyone. I'm Kelly Su, an associate with Align Partners. At Align Partners, we try to build long-term relationships with clients and partners by providing holistic solutions that meet the financial needs of individuals, families, and businesses. Being your lifelong financial coach on your side is our goal. This is the third season of our post-pandemic wealth management talk series. This season will focus on the hands-on strategies families and businesses can utilize to improve their financial positions in 2021 and beyond. Last season, CPA Amy Fan helped us understand Paycheck Protection Program loans and how to maximize our chances of obtaining one. You can view our YouTube channel, Align Partners, to view previous event playbacks. Tonight, we're very fortunate to have award-winning attorney Kristen Kaminsky here with us. Kristen specializes in estate planning and currently operates her law firm in California, Nevada, and Wisconsin. She'll be covering why estate planning fails and what to do when that happens. She'll speak for 45 minutes and then we'll have 10 minutes for questions. As a disclaimer, Align Partners doesn't provide tax or law advising. Everything provided here is for education purposes only. So without further ado, let's all welcome Kristen Kaminsky.
Well, thank you so much for that kind introduction, and thank you for having me tonight. It's really an honor to be here. So I will go ahead and share my screen here. Let's hope this works. All right, does that look good to you?
Yes.
Okay, thank you.
Yeah.
All right. Let's just go through this. So before we get started, I just want to ask you a question. If something were to happen, if the worst were to happen tomorrow, what would happen to your family, your assets, and your legacy? I want you to think about that. So during our presentation today, reflect on whether the plan that you have in place provides the level of protection that you feel that you need. So every year, nearly 16 million lawsuits are filed in state court, and almost 750,000 people petition for bankruptcy. And let's not forget about the real breakup of marriages. It's no secret that the divorce rate is one of the highest in the world, and a huge number of Americans have been divorced and remarried several times. And more than 44 million Americans regularly provide care to those with limitations in their daily activity. And then let's not forget about the real dangers of coronavirus. I do these seminars, webinars frequently, and it is really heartbreaking to see these statistics rise every time I give this presentation. But as of today, there were 25.4 million cases of COVID in the US alone, with 100 million cases worldwide. You might have seen that headline that we've broken 100 million cases, which such an awful statistic. But this coronavirus has forced many people to think about what could happen in the worst case scenario. And recently, many lawsuits over cheap, poorly drafted wills and trusts have been filed. And with the surge of free online documents and do-it-yourself sites, many consumers have no idea what their documents really mean and the huge impact that they're leaving on their family. So just to give you a background, I'll do this real quick. I'm licensed in California, Nevada, and Wisconsin, and I have received the honor of being selected for a Northern California Rising Star by Super Lawyers, which recognizes no more than 2.5% of attorneys in California. And I worked at the JAG Corps in Pearl Harbor, Hawaii, and that is a fun fact. I went to school in Hawaii for a little bit, and that was a great opportunity. Along with me, though, my whole team cares deeply about estate planning and our clients, and these are just some of the individuals I work with. My law partner, and then our associate and our tax clerk are wonderful individuals that help our organization. So clients tell us that they have 5 major concerns. first, above all, they want to make sure that they get to pass on their hard-earned wealth without the government or the courts being involved. Next, they want to avoid any unnecessary taxes or fees. And then once they've passed on, they want to make sure that their family's protected from predators and creditors. And then most important, perhaps, is they want to make sure that family isn't going to be torn apart by fighting over money and possessions. So they want their deaths to be a catalyst to actually bring the family closer together. They want to find a way to capture and pass on their family story, life experiences, wisdom, and values to the generations that follow. So there you have it, our 5 major concerns. So I'm going to show you how to prevent these concerns. But is knowing enough? No, right? It's not. So you're here, you know, take action. How many of you wanted to lose a few pounds? We all know what it takes, right? Diet and exercise. How many of us gained the quarantine 15? I know I did, but not you can't lose the weight by just sitting there, right? So just like estate planning, you can't plan your estate by doing nothing. So good job being here. So you're doing something about it. So the number one reason people don't plan is they procrastinate. You know that procrastination means putting off until tomorrow important tasks you should do today. But the trouble is tomorrow actually never arrives. It's always in the future. So that leads us to knowledge and learning. This is the second reason that people don't plan their estates, is because they feel like they don't know enough. They've heard about changes in the law, they're uncertain, they come to us in confusion. But unless you're an experienced estate planner, there's no way you can keep up with all these changes. The law is just changing too frequently. So my job today is to bring your knowledge current in the areas and let you know all of the benefits available to you and your family with proper planning. So the traditional way most estate planning has been done in America since the beginning is to focus exclusively on money and property. And so this is a kind of a narrow view. I have no quarrel with doing all of these things. But if I ask you, what is the most important thing in your life? Most will say family, right? Health, friends, values, skills, human relationships, and a lifetime of accrued experiences. So you might also add your accumulated wisdom, your lessons of life that you've learned, your education in school, your experiences in the school of hard knocks. So let me ask, what was the biggest investment that you have ever made in your life? Well, here's the clue. It's not a financial asset, probably, but many of you probably guessed it, that it's the time, the energy, the love and commitment you've made in building your family. So my mission is to introduce you to a more holistic view of legacy wealth, something more than just your finances. And in the process, you'll discover how this changes everything you've thought about estate planning. So let's take a closer look at what true wealth is all about. So this is really the foundation that we've built our lives on. It's our family, it's our health, our talents, our background, our abilities, it's our wisdom. This is the sum total of our life experiences, including our formal and informal education, our relationships, our work ethic, our commitment to our spiritual beliefs or practices. It's community, our contribution to society, our responsibilities as good citizens and neighbors. It's what we try to do at our firm. In every way, I try to make a difference. In my case, it's one family at a time. And finally, the financial. So this is the category most people think of when they think of estate planning, right? But these are our collective financial assets and material wealth. With traditional estate planning, most lawyers just focus on that, protecting your stuff from probate. But as a reality check, how do most people actually plan out their estate? Well, in my experience, either they do nothing or they create a simple will to look after a lifetime of worth and savings. But let's face it, traditional estate planning ignores some of the most important issues, like what happens if you become disabled during life, Or at the time those assets get passed on, how will they impact the surviving spouse or kids or grandkids? So planners forgot to address this important issue, and families are often split apart about these disputes about who gets the family photos or who had dibs on mom's pie plate. So more tragically, though, it's ineffective plans dumped assets on kids who only see them wiped out by divorces, and up to half of the family's wealth can be taken away from a divorcing spouse. Also, the surviving spouse and kids were left exposed to creditors, lawsuits. So these experiences had a tremendous impact on our law practice, and we vowed that we would protect clients from these issues. So why most estate plans fail? Now that you understand the components of a legacy wealth plan, let's look at some of the technical issues. So for those of you who've been procrastinating up until today, it's important for you to understand why effective estate planning should be a big priority for you. So for those of you who don't already have a plan, I'll explain why I believe most traditional estate planning doesn't work. So it's really simple. After practicing law for over a decade, my experience is that most estate plans I see are poorly drafted. They don't protect families from real life issues. People come in here with legal Zoom trusts, and then I have to go to court and ask the judge, I petition the court for instructions because it doesn't have something that it needs to say, or the trust is not funded with the client's assets. And so it's basically a worthless document. So most plans are not properly maintained by clients. They don't reflect the law changes too. They're basically like a bare bones living trust. And then when many people get married after the death of a surviving spouse, I find very few plans that actually protect the family's assets from the new spouse and provide for the children of the original marriage. And finally, the traditional estate planning never captures the legacy of your family. And that's the saddest part of all, in my opinion. So to help you understand the issues that confront families in their estate planning, I want to tell you a story. So let me introduce you to Bill and Mary Jones. They've been married for a long time, and they're right here in Northern California. They're typical of the clients we see and the concerns that they have. So they've worked hard all their lives, and they don't consider their estate all that large. And when you consider it for estate planning purposes, it's worth much more than they would have guessed. It's worth about $700,000. So you might be wondering, what if I'm single, I've never been married, or I've been widowed, or I'm divorced? Will this apply to me? And the answer is yes. All of the principles that we are going to be talking about today apply to each one of these situations. So let me introduce you to the two main reasons Bill and Mary want to do a good job with their estate planning. So that's their two kids, Jay and Sarah. So Bill and Mary have done a remarkable job building and preserving their estate for themselves and their family, but they also have lived a life built on a strong work ethic and honesty above all else. So they told stories around the dinner table about their own childhood, which helped to shape the lives of their kids. So like many families, Sarah and Jay each took a different course in life. Sarah is the golden girl. She is a CPA. She has two wonderful children. Jay, on the other hand, never quite conformed. He was a rebel as a child and continued that behavior into his adult years. He went through a couple marriages, but his biggest problem is drugs and alcohol. So he had a prolonged stay at a rehab facility, but he's never really been clean and sober for very long. So Bill and Mary have been bailing Jay out his entire life and are really worried about what he's going to do with his inheritance. So have you kept up? Let's see how this strategy works out for Bill and Mary. So they have, let's look at their estate planning options, right? So one of the options I hear is usually as a joke is they want to spend it all. Have you ever seen those bumper stickers on those RVs that say we're spending our kids' inheritance? Although spending it all might be the best revenge on your family, it's not good planning, obviously. So you don't know what kind of medical emergencies you're going to encounter, how well your investments are going to perform, how much the cost of living will rise, and so on. Another option is dying intestate. And no, intestate isn't a dirty word, but your family might be muttering some dirty words under their breath if you die intestate. That means without a will, without an estate plan, nothing. So if that's the strategy you adopt, then you're giving up the right to decide for yourself who gets your estate and who's going to administer your estate, when your beneficiaries are going to be receiving your estate and under what conditions. You're giving all that up to the state. The state then decides. So your family might be a little unhappy at that prospect. And then the three most popular options people use. One is joint tenancy. So you probably, if you own a home, if you do own a home without a trust, you probably own your home in joint tenancy. Many married couples hold title this way. Another option is a will. This is a legal document who handles your estate. You have an executor who administers your estate, and then you have your beneficiaries. Wills are very common, but you'll soon see that they also bring lots of problems with them and lots of expense. The next option is the bare bones living trust, and it's not a good idea. Most of the documents that I see that are bare bones do not work in the way that the person who created them thought they were going to work. And then finally, there's this complete protection that we'll talk about today, and that's the legacy wealth trust. So before we get to that, let's look at the most common, and that's the last will and testament. So like most people, Bill and Mary had busy lives, right? They had hectic schedules. You can see here that they have good intentions, and at the top of their list is to get into better shape. In addition, they want to plan vacations, map out their retirement goals, volunteer, and of course, as an afterthought, create a will and plan funeral arrangements, but those things can wait. Right now, Bill was anxious to start exercising, and before doing anything else, including consulting his doctor, he launched himself into vigorous activity, and you might be able to guess what happened. Bill has a stroke. So he had a 3-day stay at the hospital, got the okay to go home to Mary, who had been quite alarmed by the entire experience. And as you might expect, she suddenly felt that estate planning was now a priority in their lives. So the first person that they called was their real estate attorney, who helped them a few years ago on a real estate transaction. So this real estate attorney says, just so you know, this isn't my area of expertise, but sure, let's go ahead and create a will for each of you. So they each signed their own will, and they congratulated themselves for finally taking care of these important details. They could cross these items off their list. But unfortunately, they would soon find out that they had barely begun to address their actual estate planning issues. So just 6 months after leaving that real estate attorney's office, something terrible happened to Bill. Can you guess what that was? Well, the biggest risk for people is not death. It's becoming disabled. And that's what happened to Bill. So after his minor stroke, several months before, he has a massive episode that left him permanently disabled. So if you're too disabled or ill, who's going to handle all of the daily financial matters for you? Who's going to make sure that your gas and your electricity is paid? Is it going to be your wife, your husband? Would it be one or several of your children? Is it going to be a friend or a relative? So it could potentially be any of these people. Before they can actually step in and act on your behalf, they must first go to court and ask the judge to be appointed your conservator or guardian. So Mary has to go to court. Conservatorship is the court proceeding to name your conservator to look after things. And normally we think of probate as that often difficult court process that happens after people die, but this actually happens during your life. If you get dementia, if you have a stroke and you're severely disabled, but you live for another 10 years, and throughout this period, you're not able to handle your financial affairs on your own. So for this full 10-year period, someone the court actually chooses, not necessarily someone you would have chosen, has to go in and out of court and ask permission to use your own assets on your behalf. It sounds silly, right? How else can the family be assured that everything's being done properly? The court has to make sure of that. So the conservatorship has a potential to be a nightmare. First of all, consider the public humiliation. You have to actually be physically walked into court. And this is in front of all kinds of other attorneys, all kinds of other people in the courtroom. It's a public proceeding. You are physically walked into the court so the judge can see you and declare you incompetent. The court is now in control. You don't get to name your conservator. The court does that. And it's very time consuming. And anytime you go in and out of court, it's pretty pricey. So the court fees, attorney's fees, accounting fees, each year, the accounting has to be provided to the court detailing what money has been spent on. And that includes, $30 spent on your depends because you don't have the ability. So it's just very, very humiliating. Bill and Mary finally get through this conservatorship process, but unfortunately, a few years later, Bill passes away. So at this point, Mary has to go back to court and is confronted with the probate process. So a lot of people are confused about the probate process and why it's even needed. Some people think, oh, a will avoids probate, and that is not the case. A will takes you to probate. If you don't have a will, you still have to go to probate. So the only thing that avoids probate is generally a trust. So basically, probate's main purpose is to change title on the property you own. So if you pass away and your family wants to sell an asset or refinance or lease an asset that is in your name, they can't do so until the name or title on that account or asset has been changed into their names. So when you think about it, if you want to change title and asset now, usually sign a document to transfer title. But if you're not around, who can sign that document for you? The only institution authorized to change title from the name of someone who passed away to the living beneficiaries is that probate court. So that's the main purpose of probate. And so there are some other things that happen in probate court, and we don't have time to get into all of that now. But why should you avoid probate? It is expensive. On our website, and I think there'll be a link to that at the end of this presentation, we have a probate fee calculator. You can put in the value of your estate. So for like $1 million estate, your probate fees are about $30,000. That is a lot, and that's just attorney's fees. That doesn't include executor's fees. That doesn't include court costs. That is a lot of money that you can just not have to pay, or your estate doesn't have to pay if you plan properly. It's, again, time consuming. It is so time consuming. The average probate pre-COVID, the average probate proceeding in California was 16 months long. After COVID, everything is being very much extended. We have court hearing dates that aren't being set for 6 months in the future because everything is just so backed up because of the court closures. It is, as I mentioned, very expensive. And then it's open to the public. So literally you can walk into any courthouse in America or obtain on the website whoever passed away, their probate records would show the inventory of the estate, all the assets, who the beneficiaries are, the beneficiaries' addresses, how old the beneficiaries are. And if you don't have something in place and you have young minor kids, guess what? They inherit everything at age 18. I'm right now dealing with a probate, $700,000 going to a 7-year-old. We have to go into court every single year. And when she turns 18 years old, $700,000 is going to this 18-year-old, soon to be 18-year-old. That's kind of scary, right? Think about yourself when you were 18. Can you handle $700,000? I don't know if I'd be making the best decisions. So let's not just focus on probate and vulnerable children. Something far more valuable has been lost to this family, right? Most of this discussion is about money and financial assets, but what about the wisdom and life stories Bill had to offer his family? Where was that preserved? So isn't it true that when Bill died, all of those non-financial assets were lost as well? Sure, Mary remembers and the kids might too, but what about the grandkids and the great-grandkids? Do they remember Grandpa Bill? Bill will just be a name on the family tree, and that is so sad. So it's crucial that the family has a way to capture Bill's biography before he dies, so his memory and life will not be lost to future generations. So let's pause for a moment and look at how ineffective Bill and Mary's estate plan has been. They have not protected Bill from an expensive and lengthy conservatorship. They have not protected from the family from a very expensive probate proceeding. And perhaps most importantly, they did not provide a way for Bill's life stories, wisdom, and values to be passed on. So there are still 3 big worries after Bill is gone. Many clients are concerned that their spouse might end up getting remarried and the family's entire estate end up in the hands of a stranger. How many of you know someone who got remarried after their spouse died? It happens all of the time. But it's not only remarriage that can destroy your estate, lawsuits can wreck your plan. So as I said at the start of the webinar, 16 million lawsuits are filed annually in state courts alone. So after Bill dies, Ralph has been a good neighbor of Mary and Bill's for a long time. Ralph was married, but his wife Ruth died about a year ago. And after Bill passed away, Ralph came over to offer his condolences to Ruth, and you can guess what happened. The loneliness set in, and there's just this strong desire for companionship. So after a short courtship, he proposes to Mary, and Ralph has a couple of grown children of his own, Ryan and Rachel. And of course, the big fear is that the new spouse and his or her children are going to find a way to get their hands on the estate. And it's a common occurrence. If the spouse is naive or not paying attention, pretty soon papers are signed and estate plans are altered, and there's no limit to the greed that pops up. But how can you protect this from happening to your family? Well, it's really fairly simple. But very few estate planning documents actually have this language. So a well-drafted plan can actually seal up all of the estate of the first spouse and block it from being transferred from outside of the family. So it's also possible to insist that a prenup be signed between the new spouses as the condition of the surviving spouse having any access to the portion of the estate belonging to the deceased spouse. So these are really powerful provisions that can save an estate from prying reach of others. Also, it gives the surviving spouse a convenient excuse to get a prenup signed, right? She can say, well, it's required under the terms of my estate plan. Then she doesn't look like the bad guy for bringing the issue up. And it's difficult to prevent the spouse from giving away the portion of the estate that belongs to him or her, but you can definitely lock down the rest of the estate that was intended. So how many of you knew you could do that? Obviously, Bill and Mary's simple will had no protection for something like this. So that's another example of traditional estate planning and the failure. So what about liability? Let's say Mary was driving along one day and took her eyes off the road for a minute and ran into a bus filled with kids. There were some major injuries and Mary gets sued. So after a trial, a judgment for $2 million was entered against her. Will her estate plan protect her from those claims? Unfortunately, most do not. Most do not have a special asset protection language that will shield part of the estate from lawsuits or creditor claims. So how important is it to you to have your spouse and children's inheritance protected from these risks? So now let's go back to our story and find out how Mary is doing. So Bill passed away and Mary's the survivor. And as you remember, Mary inherited Bill's $350,000, so her estate $700,000. So the good news for Mary is that as a female surviving spouse, she has an average of 14 years to live, because that is how long on average a surviving spouse will live. But for those of you who had your spouse pass away 13 years ago, don't get nervous and think that you only have a year left. It's just a statistic. So more than half live over 14 years. So Mary lives another 10 years. And thanks to her wise investing and inflation, Mary's estate of $700,000 grows to $1.4 million. So Mary unfortunately develops Alzheimer's disease and is no longer able to handle her affairs or properly look after herself. She has to be placed in a nursing home. And statistically, more than half of us are going to wind up in a nursing home or some long-term care facility sometime before we die. And to show how that problem is growing, a recent study by the Alzheimer's Association declared that dementia is the biggest health crisis facing the world pre-COVID. Estimated by 2050, 3 times the number of elderly will need care more than today. Now we have another conservatorship, and this is the process where the family has to go in front of the judge and ask someone to handle Mary's affairs. So who are they going to appoint? Jay or Sarah, or maybe somebody else? Do you want to leave it up to a judge? Do you want to have your kids fighting about who's going to take care of you? Because Bill and Mary only created a simple will, they have no choice. The family must endure another conservatorship. So after a relatively short stay in that nursing home, Mary passes away, unfortunately. At this point, Bill and Mary are both gone. So can the estate just be distributed to their kids? The answer is no, because Mary's estate, all of her assets must go through probate. So once again, let's not lose sight of the non-financial assets. So money comes and goes, but the wisdom represented by Bill and Mary and their family is a priceless treasure. If you're like most families we see, nobody's taken the time to interview mom and dad in a written session, and that is such a tragedy. So no one's even thinking about the generations to come. Sure, the kids know mom and dad, and maybe even the grandkids have some idea of who grandma and grandpa were. But what about the generations after that? What would you give to have known the lives of your grandparents or great-grandparents, or to see yourself as part of this unbroken family heritage? A big part of our legacy wealth planning is helping you write down those life stories of the family elders. And we believe that estate planning is not complete until this has been accomplished. So how much did Bill and Mary's will-based estate plan end up costing the family? We start with $1.4 million. We look at probate fees of $54,000 plus court costs and expenses. And so there's about $1.3 million to leave to the children. So $54,000 is a really expensive estate plan, I think. So financial maturity, in this case, Jay and Sarah are each going to be receiving several $100,000 outright. And this represents a lifetime of hard-earned wealth by Bill and Mary. So let's look at what most clients fear after they're gone. So fortunately for us, specific research has been done on this topic, so we know the top risks that clients worry about. According to Financial Planning Magazine, when clients were asked about the security of their wealth, the number one concern was that somebody would take financial advantage of their children or their grandchildren. And it's even more important when the parents are no longer alive or able to look after them. So Bill and Mary have taken no steps to make sure their wealth is not wasted once they're gone. Their simple wills dump this huge windfall on both of their children. So the top 3 risks that parents tend to worry about are divorce, opportunists, and lawsuits. So every client is worried about the son-in-law or daughter-in-law divorcing their child and walking away with a big chunk of their estate. And why shouldn't they worry, right? With divorce rates in America topping every other country, the chances of your kids having a long and happy marriage are not good. Parents also worry that someone will target their kids or get rich quick schemes, foolish financial investments, or even some well-planned scam. And then there are real prospects that your kids could get sued with some judgment creditor walking off with your estate. So let's start with divorce protection. Here we see Sarah's lazy husband, Jason. Bill and Mary never liked him. Despite the fact that they love their grandbabies, they felt like Jason was bad news. He has a hard time holding down a job, and he's never been very ambitious. Sarah has always been the main support of the family. And after the assets were divided, each share was handed the kids outright in one lump sum. So once Sarah received the money, she deposited it all into her joint bank account with her husband, Jason. And a year after Bill and Mary's death, Sarah finally has enough of Jason's behavior and files for divorce. Well, how much of Sarah's inheritance will Jason walk away with? For those of you that guessed it, about half. So in one quick move, about half of Sarah's inheritance is gone and into the hands of a guy Bill and Mary never liked. So how many of you know about a situation like this? Believe me, it happens all the time. Can our planning do better? Can we keep Sarah's inheritance in the family even in the face of a divorce? Well, we've talked about divorce protection, but what about lawsuits and creditor claims? So obviously this is a huge risk for somebody like Jay. He's never had much money before, and now he's just received several $100,000. Well, the first thing he does is go shopping for an ultimate muscle car, the Corvette. He buys the souped up model that goes from 0 to 60 in 4.2 seconds. He's proud of his new toy, and he finds every occasion to race it. So you probably think I'm going to tell you that Jay gets into this serious accident, but he will one day, but that's not the story I'm going to tell you. The source of his problems are the IRS. Apparently, Jay had not been filing income tax returns for several years. So Bill and Mary should have never left their inheritance to Jay outright, because the IRS walks in, swoops all of that money right out of Jay's bank account. The question is, can we draft a solution that protects Jay from himself? And the answer is yes. So Bill and Mary's estate plan failed at almost every turn. Unfortunately, this is the kind of estate plan that most Americans think is adequate to protect their family. It's truly a sad state of affairs. The plan that they relied on had actually no protection in the case that either of them became disabled. There was no way to keep both of their estates out of probate. There must be a better alternative. So let's examine what we believe is a much better way. So it's called a living trust, and it's a complete will substitute. So this is kind of a do-over for Bill and Mary. So Bill and Mary certainly messed up their estate plan, but let's give them a do-over. And just like the defective one-size-fits-all wills on the internet, as well as those drafted by inexperienced attorneys, there's a lot of bare bones living trusts. They're out there. The majority of living trust documents that people bring into my office to review are the stripped down plans. It's rare when a trust meets all of the criteria that I would draft. The living trust is designed in the bare bones case to do one thing, and that's avoid probate. In many cases, however, the assets are not even transferred into the trust. So like I said at the beginning of this webinar, it does nothing. So what kind of planning should we be looking at? So I'm going to introduce you to legacy wealth planning. This is the planning used by a small number of highly trained law firms in the country and endorsed by the American Academy of Estate Planning Attorneys. So legacy wealth planning is designed to protect the whole family, including your family values and history, not only while you're alive, but for generations after your death. So it's made up of two important components. First, it addresses all of your family values and history, not only while you're alive, but for generations after your death. It shields your assets from conservatorship, remarriage, probate, divorce, lawsuits, and creditors, and allows access to the funds by your heirs. It helps to avoid family feuds. And second, most importantly, is it's leaving your legacy, your biography, your life stories, your wisdom for generations to come. I know we don't have a whole lot of time, so I will wrap the rest of this quickly up. But the magic here is how you hold title to your assets, right? So it really, really matters how title is held. So you want to make sure that all of your assets get funded into your living trust. So for hundreds of years, trusts of all kinds took title to property for the beneficial use of others. Think about a trust like a big treasure box. We create this trust document, right? It has nothing in it. All of Bill and Mary's assets are still in their own names. The trust has control of nothing. So if something happens to Bill or Mary before we get title to assets into the name of the trust, they will have all of the same problems they had before. So the key is retitling the assets into the name of the trust. We help you with that. So we prepare your deeds and all of that and funding letters, and we hold your hand through that process. So you're probably asking, if all of my assets are in this legacy wealth trust, who has the power to manage this property, pay bills, etc.? Great questions. And the answer is you. So there are 3 positions in a trust: trustors, trustees, beneficiaries. And you are the trustor, you are the trustee, you are the beneficiary during your life. And in Bill and Mary's Legacy Wealth Trust, Bill and Mary are all 3 positions. They have total control of their assets. They act as the trustors, the trustees, and the current beneficiaries. So what does it mean to be in total control? Well, it's business as usual. So it doesn't really change anything. They can amend their trust. They can revoke it anytime they want. They have all of the rights to manage the property, and their income tax forms are filed the exact same. Nothing changes. So it's a revocable trust, and the government ignores the trust for tax purposes and continues to tax Bill and Mary as individuals. So what's the point? Why do we do this if nothing has changed? Well, because of everything that we've talked about, no court involvement, it protects you from all of those attorney's fees, all of those delays in transferring assets. So the trust doesn't just operate when you're alive, it spans several time periods. We can create these sub-trusts for the benefit of your children. And so when Bill and Mary are still alive, everything's fine. But when Bill has a stroke, the trust takes over. They don't have to go to court. It's amazing. It's beautiful. When Bill dies, does the estate go to probate? No, it doesn't. Everything just goes according to the terms of the trust. We don't have to go to court. We save all of this time, all of these fees, and we capture Bill's memories, his wisdom stories, his life lessons. These are all captured through the legacy wealth planning. What do we do about Ralph? Well, we draft something in there in the trust that says if Mary decides to get remarried, we protect Bill's portion of the estate from getting commingled with Ralph. We can design the legacy wealth trust to block any estate transfers outside of the family. We can require that prenup. Liability protection, it's all in there. Mary gets Alzheimer's, we don't have to go to court. We don't have to go through probate. Just as we did with Bill, we capture Mary's life lessons, her stories, her wisdom. So protection for literally every issue we've just talked about. Now we're down to the 3rd period. The first period was when Bill and Mary were both alive. The second period was when Mary was the survivor. And the 3rd period is when Bill and Mary are both gone and the estate is ready for distribution to the kids, right? So $700,000 to each of the children. Well, a trust is like squeezing toothpaste out of a tube if you get an outright distribution from a trust. But we don't want that to happen, right? Because the toothpaste can never go back in the tube. The money can never go back in the trust if you're entitled to an outright distribution. So a trust protects you from that. We can have sub-trusts set up for these beneficiaries protection with Sarah. We can have her sub-trust protect her from divorce. With Jay, we can have his sub-trust protect him from his own creditors. It's pretty great. And then there's this family incentive trust. If Jay cleans up his act, we can put some incentive provisions in the trust. Hey, if you clean up your act, you get some more money. Sounds pretty good. We also have special needs provisions for special needs child. So what do you think is the most important ingredient of a good legacy plan? Might surprise you to learn that it's not the technical issues, but after meeting with many clients over this past decade, I believe that the most important ingredient is making sure that what is most important to you is actually reflected in your plan. So again, trust that you find on the internet, it's like a gorgeous pen without ink. It's worthless. The document doesn't work. We're still going to have to go to court and do everything as if the document didn't exist. Oh, and just what you should know about pricing if you work with an estate planning firm, I always recommend working with a firm that does a flat fee rather than an hourly fee, because you might have questions. You might have a lot of questions. And every single time you spend 1 minute, the attorney bills a 0.1, and it just adds up. So I would recommend working with an attorney who does a flat fee for estate planning. So the information part of this is over. So there's no way that, you have all of the information you need. So I am happy to meet with every one of you to, have a conversation about your estate plan. But I leave you with one final thought. And Pablo Picasso, who is generally known as a genius in artistic matters, admonished others not to procrastinate. He said, only put off until tomorrow what you are willing to die left having undone. So I'm ready to help you take care of it so you don't leave things undone. So thank you so much for having me. And I am happy to answer any questions if you would like. And I will stop my screen share here now. Okay.
That was fantastic. Thank you so much, Christine.
Thank you.
It's such a luxury that we can stay in our living room and
Oh,
listen.
isn't that nice? Yeah.
Thank you. Yeah, thank you, Kelly.
Okay. What a great presentation. Thank you, Kristen. So the idea of this seminar is for people to shift their active income into passive income. For that reason, every family will have to think about these 6 foundations, all of which will be covered in our seminars. Actually, Align Partners offers both Chinese and English classes that covers these topics more in depth. Classes are available for free for individuals who are partnered with Align Partners. If you're interested, please don't hesitate to contact us. For this page is our contact information. Feel free to screenshot it for future reference. First, we have Kristen's phone number and her website. The middle one is the QR code for our WeChat group, our YouTube channel, our phone number, and our website. The last QR code is for anyone who wants further assistance. So for the last section, for anyone who has questions, please unmute yourself or leave it in the chat below.